Great. Thank you, everyone. I think we can start the closing session of the first UNODC Knowledge Week on Trafficking in Persons and Smuggling of Migrants. Kindly be informed that this event is being recorded and make sure that your microphones are muted at all times. I would like to thank all of you speakers and participants for joining us in the last day of the Knowledge Week. We are overwhelmed by an unprecedented level of participation in this week. We have received more than 600 registrations for this series of events, and it's amazing that you are dedicating time of your precious Friday for this discussion. Today's closing event is about making everything that we discussed in the previous days work. This session closes a week of discussions on very topical and complex issues around trafficking in persons and smuggling of migrants. It is when we try to apply the principles and the concepts enshrined in the protocols and in international legal instruments where the complexities are illustrated. And let's be very honest amongst ourselves, adjudicating on trafficking in persons and smuggling of migrants is a complex process. The very definitions of these crimes are rather complex. And case law is a microcosm. It's a micrography of the whole trafficking ecosystem. You have victims, witnesses, an offense, defendants, trial attorneys, defense attorneys, prosecutors, judges, service providers, NGOs participating in that process. And it's a representation of a whole path towards delivering justice. And it is in this process that we want to dive in and see how the mosaic of evidence, as one of you in this panel knows very well, is put together to achieve convictions or exonerations, to deliver justice or a miscarriage of justice at times. And case law is also the basis of a lot of analytical work that we deliver as UNODC. We have published a lot of tools based on case law that you can find accessible openly in the knowledge portals of UNODC, where we store more than 2,000 judicial decisions from more than 100 jurisdictions around the world. We use case law to help practitioners, and based on our work on case law, we can conclude that there is no shortcut in addressing complex issues around trafficking in persons and smuggling of migrants. There is no reductive way, but there's always a creative path for judges and criminal justice practitioners in applying these very complex notions. And there is no better context to illustrate this complexity than case law. And I'm joined in this panel by professionals that have a distinguished career related to case law somehow. We're very honored to have with us Judge Turkovic, the Vice President of the European Court of Human Rights. She creates case law. We have with us Rachel Gershuni, who worked with case law and has dived into a vast constellation of case law globally and tried to systematize it. We have with us Judge Ramangura from Thailand, who saw usefulness in systematizing case law. And we have with us Fabrizio Sarica, who leads the most comprehensive data collection exercise globally on trafficking in persons. They will be sharing with me their insights, and I want to start off by Judge Turkovic. I wanted to ask her, as a judge and vice president of the European Court of Human Rights based in Strasbourg, you produce case law. You deliberate and adjudicate on cases. Could you talk to us about the power of case law in advancing international legal standards around trafficking in persons and smuggling of migrants? We know that it is in each word of your deliberations and decisions that many criminal justice practitioners service providers, NGOs, academics rely to build a case or advance further their advocacy efforts. Do you consult case law in the process of deliberation? Can you talk to us about the impact that you see of case law, and how could UNODC help you in any manner in this way? Judge Turkovic, the floor is yours.
I unmuted. Thank you very much. It's really a fascinating issue, and I'm so happy that I'm able to talk to you and to address your public in this respect. I was a professor before that. I was a lawyer. I did many different things, and I remember I came to the court and one judge told me, you know what? You are coming to a different world now. It's nothing what you have been doing up to now. If you thought that you were creating the law, forget it. This is the place where you will do it. So, and it's really like that. And it's a fascinating things, you know, that are happening in the front of court, and it's a great responsibility. And sometimes I think better not to think, because you might be afraid, you know, of the decisions that you are making. So as you all well know, the convention is seen as the constitutional instrument of European public order in the field of human rights, and the court's principal task is actually to overview the observance of the convention by the states. And in doing that, we are receiving individual applications, and our task is to resolve the individual application and to provide individual justice in the individual case. But at the same time, the task of the court is to elucidate, safeguard, and develop, and we call it living instrument, no, the rules instituted in the convention, and thereby contributing in these ways to the observance by the states of the engagements that they have undertaken. So the court has these two rules, these two tasks, and the importance of the case law comes in these two ways for the whole Europe, but also for the you know, the influence of our case law is much wider than the European continent. Brighton Declaration has said all laws and policies should be formulated, and all states officials should discharge the responsibilities in a way that gives full effect to the convention. So, you know, the obligation to follow the convention and to protect the human rights is not only there for the domestic courts, is for all the authorities on all levels. And then the control on the domestic level of all of that is on the courts, and they have and then subsidiary we come into the picture. For a long time, the court was primary protector of the human rights in Europe, but then with time and with development of our case law, it has been realized that actually this task is impossible for the court. And with the time, the court has developed such abundance of the case law that it became possible for the domestic authorities actually to overtake, to a great extent, the function of the protectors of the human rights. And if you are just looking at the case law that we have produced up to now, for example, more than 500 grain chamber cases, judgments and decisions, around 50,000 judgments and decisions at the chamber level, and then around, I don't know, 30,000 on the committee level. But this is, and that will you know, increase considerably, because with new strategies, we are actually solving more and more cases at the level of the committees. All repetitive cases are going to the committee level. So this is really in terms how the court is looking at its own case law, and its own task is that basically, you know, we have a new strategy since almost few months now, I would say, where we are the main issue for us is how to make us more even more visible and more efficient and how the court could have more impact. And that means that we have to be up to date. To be up to date on the most important cases. And these are the cases that are actually developing or clarifying the case law. And then at the same time, somehow to be able to deal with all the repetitive cases, but much faster. So what we are doing now and what we have started from the 1st of September, that for all repetitive cases we have developed summary judgments. So all that will be done in much efficient and simpler way, but all the things that are developing something new, clarifying, or the judgments that have impact, they will be done at the chamber level. So you see, the court is trying at the same time to provide individual justice and at the same time to give the guidance for the ways in which human rights could and should be implemented at the European level. Of course, the court is doing that in the dialogue way. So it's not that the court is trying to impose anything, but the court is really open to the dialogue with the national courts and institutions, but primarily, of course, courts. And when the chamber judgments are there, the court expects that domestic authorities react. And if they see that it could go further, that the court went into the wrong direction, that, you know, that we enter into the dialogue, and finally we end up in the grand chambers that are actually trying to resolve if there are any misunderstandings or different directions, or you know, the states want to go in a different direction, they want more, or the consensus maybe is not there, or whatever. So the court, when we are looking at the human trafficking, actually this is a fascinating area in this respect, because human trafficking is not something that has been mentioned directly in the convention, and introducing human trafficking into Article 4 was actually the act of living instrument, if we could say like that. And in these terms, Rancev judgment, that was the first judgment that introduced human trafficking under Article 4, was really extremely important, and it was it was significant. The court there, relying on the Palermo Protocol and anti-trafficking convention and definition of the human trafficking in these instruments, introduced human trafficking in Article 8, under Article 4, under the protection of Article 4 by itself. So human trafficking doesn't have to be related either to slavery or to whatever, or to servitude or to forced labor, but human trafficking as such is protected under Article 4. Also, in this judgment, it was really important that the court dealt a little bit with the definition of trafficking, but what was the most important was that the court has developed and described and clarified the obligations, and in particular positive obligations of the state when we are talking about human trafficking. And when we are talking about positive obligations, already in Rancev, it was made clear that the states have obligations to provide a legal framework, and not only legal framework within the, for example, criminal law and criminalizing human trafficking, but, you know, the ways how businesses are regulated, the ways how visas are regulated, and so on and so forth. Then the court has said protective measures should be there, preventive measures for the victims. The court has said, yes, effective investigation, prosecution, and punishment where warranted should be there. The court has said mutual assistance between states, if we have international elements involved, should be there. And then through the case law, the court further developed, and either clarified or just, as I would say, reinforced the things that we are finding in international instruments. So, for example, when we look at for example, J and others versus Austria, the court has clarified no universal jurisdiction for human trafficking. Then the court has clarified that, for example, there is that the obligation to provide for victims could be separated from the obligation to investigate. And even if the state does not have the obligation to investigate, it has the obligation to provide for the victim. Or, for example, in Chowdhury versus Greece, the court has clarified the relationship between human trafficking and forced labor, and that the forced labor is, of course, one of the forms of exploitation under the definition of the human trafficking, but that you could have at the same time under Article 4 responsibility for human trafficking and for the forced labor, so that they can coexist. The court explained in that case consent and the approach to the consent, and when we don't actually have consent and when the consent won't be taken into consideration, and insisted on the necessity to interpret domestic law in light of the international instruments. And the way how relevant international bodies are interpreting international law. What else? SM versus Croatia was very important to emphasize the relationship between human trafficking and prostitution, and to clarify the forced prostitution as the actually a form of forced labor. So that was really important in that case. Also reinforced what we are finding in the Council of Europe Convention, that transnational trafficking in human beings and national trafficking in human beings both are not acceptable. Also reinforced certain things that Greta is doing, especially in terms of victims' testimonies and so on and so forth. And then how the court is contributing that all of this is actually reinforced at the domestic level is through the execution that is not done by the court, but is done by the Council of Europe, the Committee of Ministers and Execution Department, where number of individual and general measures are implemented, and the states are having discussions with the Execution Department and Committee of Ministers what and how to implement. So, for example, in terms of individual measures, what is usually done, it's of course just satisfaction, and states pay that regularly, but very often we have either a reopening of the proceedings in terms of reopening of the investigations or the reopening of the case. If the states haven't granted victim status, they grant victim status to a person. They give to a person the ability to stay in the state, to get the employment, to get the place where they can stay, and so on and so forth. So we see all these individual measures that have been executed in the cases that have been in front of the court. And then general measures, and it's really the court is helping, that maybe certain international documents find their implementation faster and in fuller extent. So, for example, when we are looking in Rantseva, what was the result in terms of the general measures? It was, for example, that Cyprus and Russia introduced a law which criminalized human trafficking after that case. Or, for example, that Cyprus abolished artists' visa, which were the way how the human trafficking was somehow introduced in Cyprus, and they started to cooperate much closer with Greta. Or, for example, in two Greek cases that have been already closed, of course, always the judgments are widely published and distributed. But, for example, in Greece, they established special police force, national reporter for human rights, for human trafficking, special commission in the parliament for combating human trafficking, and so on and so forth. So you see that actually our judgments are helping to introduce international standards faster and in a way, in more comprehensive way at the national level. Thank you.
Thank you very much, Judge Turkovic, Professor Turkovic. I can see the many ways that the court has consolidated, clarified, elucidated principles, and even the very convention of human rights in relation to trafficking in persons. You gave us a great path to go to Rachel Gershuni, who is a woman with many lives and many hats for her head. She will talk to us about her experience analyzing case law, working with case law, and developing the case digest on evidential issues. It's a flagship publication of UNODC that looked into a big number of judgments from around the world and tried to put together what we call the mosaic of evidence in challenges, and examined also how courts overcame challenges in creative manners. Rachel, can you tell us a little bit about this experience, and also, in your opinion, what is the impact of case law at the national level? The floor is yours. You must unmute yourself.
Hi. I wanted to mention that the work on the case digest, the global case digest, has been supplemented now by work on a regional case digest for the Southern African region. And I was able to get even more insight from doing that on a regional level. And the basic insight from all the case digests, both case digests, is that cases are crucial. However excellent a country's legislation, it can't cover everything. It can't cover all eventualities. You must have the case law to breathe life into that legislation, as the judge has said. The basic, again, insight from both case digests is that there are typical issues in trafficking in persons cases. And these typical issues are encapsulated in the term that you used, mosaic of evidence. Trafficking cases need many circumstances to prove them. First of all, there are three elements: the act, the means, the purposes of exploitation. But each of these elements can also require several circumstances to prove it. For example, how do you prove slavery? How do you prove the ownership aspect of slavery? Well, you might have to deal with the difficult conditions. You might have to deal with signs of ownership. You might have to deal with violations of dignity. So you will always have a mosaic. You're never going to have one main a piece of evidence which proves the case, as you do in crimes like grievous injury. You have the wound. Okay? In trafficking, you need a mosaic. And each part of the mosaic may be of different weight, but all of them can contribute to the conviction or to the exoneration. Now, in this brief time that I have, I would like to talk about a crucial weakness which courts have addressed, and that's the seeming consent of the victim to his exploitation. From the very first moment that I started to deal with trafficking cases on a national level, I began to see very strange statements and behavior of victims. Victims would say about the trafficker, "He was my best friend. He was the only one who took care of me. He was my best alternative." Or we would have strange behavior, like the victim not escaping when he could, not seeking help when he could, returning to the abuser time after time after time, not attempting to object to what the abuser was doing, even though other victims were doing so. And so looking at the laws and looking at the protocol, you would think that this weakness is completely solved by legislation, because most trafficking legislation follows the protocol and says that consent of the victim to the intended exploitation is irrelevant. Okay, irrelevant if means are present, irrelevant even if not, if means are not present. So this seems to solve the problem. However, as we saw in a fascinating UNODC publication on the role of consent in the protocol, consent is always a live issue in courts, okay, despite the legislation. And the question is why? Well, two reasons that I can think of are, first of all, judges are criminal justice practitioners. And in the criminal law, often consent is the whole difference between something that is permitted behavior and a crime. Take rape. If I agree to sexual relations, it's not rape. Take assault. If I agree to your touching me, it's not assault. It's hard to overcome that. In addition, I teach this course in the university in which we deal with consent. And I was reading a lot of the philosopher John Stuart Mill, who is the leading philosopher who has influenced the modern age. And the value of autonomy, okay, is a very high value in modern life. We owe this to John Stuart Mill, I think, among others. And we think that we need to give weight to autonomy. In other words, if the victim decided to do something, it may be a bad choice, but we give weight to that choice because we give weight to autonomy. So for these two reasons, even though it expressly states in practically every trafficking legislation that consent is irrelevant, consent is always very relevant. So this makes it clearly evident that case law is crucial to establishing guidelines. And I would like to give 3 examples of cases which took this seeming weakness and actually transformed it. I would call it a kind of judicial alchemy, transformed it into a strength. First, we have the Kovacs case from Australia. Here we have the case of a victim who was sexually exploited and also exploited in terms of slavery, forced labor. She worked every day in a takeaway food store where she saw the public every day of her work. And yet it took her 5 months to escape from the situation. Instead of seeing this as a weakness, the court saw this as a mark of the level of control that the trafficker exercised over the victim, that even though she was not locked in, even though she was facing the public every day of her life, his control was so strong that she did not feel she could seek help or escape. Interesting. Similarly, in the United Kingdom case by the name of Connors, the traffickers recruited homeless men who were addicted to alcohol. And while some of them fled their situation and were not recovered, certain of them didn't even try to do that. Now, this could have been seen as a weakness, but the court, and here I have to read you what the court said because it's just so beautiful and so powerful that I have to read it to you. It says, one manifestation of the level of control was that many of those exploited were effectively deprived of the will to leave, and others were too demoralized to seek to leave, and yet others believed that the world outside had nothing better to offer them. This is a powerful statement. No, it doesn't show that they consented. It shows the level of control. The third case I take from South Africa. This is a very interesting case. Ease, the state versus Ease, about 2 addicted young women who are trafficked for prostitution. Now, one of these young women, who I really would like to meet someday, she was praised by the court for how she handled herself. She had a very good support system. She was a citizen of South Africa. She had loving parents who took her in time after time, and yet she failed to flee, and she returned to the abuser time after time. Now, when the court was analyzing this, it could have seen it as a weakness. Well, she consented to the exploitation. That meant that it was her autonomous decision. But no, again, the court viewed her addiction and said, in her addicted state, the victim is experiencing overwhelming cravings for the drug and will do what she can to satisfy them. She has impaired judgment and is susceptible to control. Further, the court says that drugs help the traffickers keep prostitutes virtually enslaved. So we see that in all three cases, the court did not exonerate on the basis of a checklist of weaknesses, including consent. They analyzed in depth and viewed the vulnerabilities of the victims and the level of control of the traffickers. This is how case law infuses life into consent. Okay, I don't have much time left, so I will just answer your question about the impact of cases. And I will share with you that I have often been in despair and thought that case law has no impact and that nothing has any impact. However, I do have two assurances that case law does have impact. One, on the international level, when I began to read the 80 cases from the Southern African region, I was very encouraged by the fact that not only do they use their own national cases, they use international cases from all sorts of countries, and including the European Court of Human Rights. So this was very encouraging for me. A second assurance I received on a national level. In Israel, there was a very hardcore sexual exploitation trafficker who brought many young women into Israel for prostitution. At some point, he stopped bringing them into Israel and brought them into another country, which I will not mention, because of the stringent enforcement and the case law. And in one tape recording, the trafficker actually said, oh no, I've changed the way I do things. I'm not bringing them into Israel anymore. So what do we see from this? Yes, case law and enforcement has an impact. And besides, despair is a luxury. That's it. Okay.
Thank you very much, Dear Rahel, for this thought-provoking intervention. You highlighted the fact that case law transgresses borders. As Judge Turkovic also mentioned before, the impact of a regional court can go far beyond the borders of its own, jurisdiction. And a proof of that is Judge Ramangura, who is joining us today in this very late for Bangkok time to share with us her experience spearheading. She led the development of the translation of the case digest of UNODC on evidential issues in Thai, so for the context in Thailand. I'm very honored to have her in the panel, and I wanted to ask you, Varamon, Judge Ramangura, about your experience with this process. What was the reason that you decided to translate the case digest, and how is it put in use today in the judicial practice of Thailand? The floor is yours.
Yes, so thank you very much. I am very honored to be here and to have been invited to speak about my experience on the translating and publishing of the UN ODC case digest. I looked at the panelists and I could not believe that I was chosen to be among such esteemed speakers. So you talk a little bit about my background, so perhaps you know that before becoming a judge, I used to be a project officer at IOM, and I used to do research a little bit on human trafficking. So even before becoming a judge, I had a little bit of background on trafficking. Maybe that's why I was assigned this responsibility, but I rather think that is my destiny. I worked until this September. I worked at the Office of the Judiciary. So for 5 years, I didn't go on the bench, but I worked as a buffer between the Court of Justice and other entities. And I respond to the national and international forum on the issues relating to trafficking on behalf of the Court of Justice of Thailand. And that's how it all started. And first, I would like to talk a little bit about the background of trafficking in Thailand for those of you who are not familiar with our situation. Because of our geographical position and economic opportunities, we have been accused of being a source, destination, and transit country for trafficking victims. Because of our location, we are situated in the center of Southeast Asia, a convenient location to trafficking victims. And because of our growing economy, we also attract labor migrants from neighboring countries who are, of course, vulnerable to being victims of trafficking. And the situation has been going on for a while until 2014, the U.S. State Department Influential Annual Trafficking in Person Report, or we all know as TIP report, downgraded Thailand from Tier 2 watch list to Tier 3, the lowest ranking possible. And it was really a wake-up call. Combating trafficking has become our national policy. With our effort, we were elevated to Tier 2 watch list in 2016 and to Tier 2 in 2018. But this year, we were again downgraded to Tier 2 watch list, first time in 4 years. And the reason always cited in the recommendation for Thailand was the lack of understanding of law enforcement officers on the concept of human trafficking. So as the country struggled to solve this problem, the Court of Justice and also the country eventually realized that the judges play a very important role in combating trafficking in person. More than just deciding whether the accused is innocent or guilty in their sentencing consideration, we also have to make key decisions on the interpretation of trafficking law and the evidence required to establish the crime. The court decision also reflects victim identification criteria and impact upon the assessment of victim credibility, and may also involve the step to ensure the protection of victims during the criminal procedures. So all the court work are critical to the overall success of Thailand anti-trafficking effort. Not only we realize this ourselves, we were also approached by many government entities and NGOs on how the court. We were asked to answer to the government on international level on how the court can improve their effort to combat trafficking in Thailand. And so, as we all know, the concept of trafficking law differ from the concept of general criminal law that we know, like consent that was mentioned above. And as you know, judgeship is a very isolated occupation, especially in Thailand. Most of us only meet with judges and court staff in our day-to-day work. And when we have training, we have training, but it's mostly done by more senior judges to the less senior judges. So in the past, until the past 4 or 5 years, we never have an outsider coming in and train a judge. So as a staff at the office of the judiciary, and I enjoy meeting with other government agencies. I answer questions on human trafficking on behalf of the Court of Justice. I saw that there were some issues and there were some misconception about trafficking law that perhaps could be improved among the Thai judges, and that we may need to outsource expertise from international experts. So in addition to our involvement in the new in drafting the new legislation, we enacted a new law called Criminal Procedure for Human Trafficking Cases in 2016. It was led this legislation is about the procedure used especially in human trafficking cases. And I was lucky to be involved, and the legislation was largely headed by a group of judges who try to respond to the pressure to improve on the procedure on how the court handle trafficking cases. In parallel, we also conduct seminar on the new legislation and training to promote guidelines from the Trafficking Division in the Court of Appeal, and also a training on evidential issues. And I realized the importance of this. So I proposed a 2-week training program at the Hague Academy of International Law in cooperation with UNODC, and realizing the importance of the issue that the Office of the Judiciary supported this program. And so we have about 40 judges trained during a 2-week program in the Hague Academy of International Law, and that's where I met Soy, because I was working as a translator. And during the training, the case digest was introduced by speakers from UNODC, and it received a lot of attention from the Thai judges. I was surprised on how they were enthusiastic to learn about the case digest, because in Thailand it's very difficult. We don't have that many number of trafficking cases, but each case has such an important impact on the country and also on the judiciary. And so I thought, because most judges who deal with trafficking cases, they may have the intention to combat trafficking, but they do not necessarily have a high level of English proficiency. And I thought that it was such a pity that a language barrier would bar them from the access to this very useful tool. So after I came back to Thailand, and I continued working as a representative of the Office of the Judiciary on trafficking issues. Again, I was approached by many NGOs and who would like to work with the Court of Justice, because like I said before, we were not as open as this, but after we were downgraded and after we faced a lot of pressure to improve our practice, then we try to be more open. And that's where I work. And many NGOs offer us financial support for our activity. But there was this one NGO, it's called Mass International, requested a meeting with me, and we met in my office, and they said, look, we really want to support your work on human trafficking, but we don't have funding to offer. Is there anything we can do? So I stretched for, and I think that they are international NGO, and they work, they have legal expertise, and they can speak English. So I asked them straightforwardly whether they would be interested in translating this document for the Office of the Judiciary, and they agreed immediately. And so, having been to the Hague Academy of International Law, I knew Soy and her colleague Tagias from the training. So I sent them an email whether is this okay, whether we can have their permission to translate this document. And after they gave us green light and connected me to Dr. Rebecca Miller, who works as a UNODC regional officer on human trafficking in Bangkok. And so we met, and in the end, we managed to find funding for the publishing after it was translated. And after that, like I say, we have some funding offers from NGOs. So we managed to find funding to conduct a 2-day training across the country for regional judges based on this case digest. So this is my experience on working on this. And after we published the UNODC, we gave the material to all the workshop participants. And we have some exercise and and some question and game that we play during the workshop to make sure that they understand. But I was talking to Dr. Miller that the important thing is not that everybody in the workshop become an expert on trafficking, because just 2 days is impossible. But at least we want them to know that there are material, there are resources that they can reach out for, and because we don't have enough books to give to all the judges in Thailand, there are about 5,000 of them, and we work on rotation basis. So one day, a civil court judge could become a criminal court judge, who knows? But we have an e-book, and we promoted an e-book, and then I have some copies with me. So whenever I have a friend who is a research judge at the Supreme Court of Thailand, and his work is to review a Supreme Court decision before to give a review and comment on Supreme Court decision before it is read. And he knew that I worked on it, and he directly contacted me and asked if he can have a copy. And of course, I gladly sent him this. So, and he told me that it was very useful because he disagreed with the decision, and he tried to fight with the judge who wrote the decision. And unfortunately, he lost. But at least I saw the effort, and I think it's a good start. So that is my experience. It seemed a bit. Talking like this, it seemed a bit easy, but as you can see, I could not have done all this by myself. Without help and cooperation, both within the court and outside, both at local and international level, I would not have achieved anything on this. But if you ask me how I get assistance on this, I would say that I have before this publishing and translating, I had worked on human trafficking for a while, not as an adjudicating judge, but as a middleman between the judges and the outside world. And I would say that when you do something with your heart, and when you make the work your aim, the others who do the same and in your field and or profession, I think they will recognize it, and they will help you do your work. And at least this is my experience on working with the case digest. And so our effort was also cited in the TIP report that we had a joint project with UNODC, and when the country was upgraded to tier 2, and unfortunately we are downgraded again. But I try to look at this in a positive way, because we are not doing this just to please the TIP report team, but we are doing this for our own country, for the victim. And in a way, being downgraded is a wake-up call, or is a reminder to us that we still have work to do. There are many room for improvement, and they just help us identify where we need to improve ourselves. And so that is my experience. If you have any questions.
Varamon, thank you so much for a hands-on and honest, I think, sharing of your experience. And it's always a great pleasure to be working with professionals and criminal justice practitioners like you that are engaged, and it comes from their heart. And I think this is visible. And now for something not so completely different, but I will turn to the man that has been leading for many years already the most comprehensive data collection exercise on trafficking in persons at the global level. Fabrizio Sarica has been the person behind the global report on trafficking in persons. And this year's report, the 2020, the latest report, included a different approach. It was informed by case law. I want to give the floor without delay to him to talk to us about the quantitative research that he's leading, and ask him how, from the quantitative side of the research, we can help qualitative work. And Fabrizio, if you can also talk to us about the challenges you're facing in your work. Thank you. The floor is yours.
Thank you, Zoe. Thank you very much. And since I'm actually the last panelist to speak, also for the entire week, I would like to express, to send you one word of gratitude and congratulations for this week I tried to attend as much as possible. I thought it was very interesting and very needed. So I hope this will turn into a tradition for UNODC. Going to your questions, yes, I am a pure researcher, but as this panel has demonstrated, sometimes research and practitioners goes hand in hand. So for the global report and research in general, what we do is to try to enhance knowledge, hoping that this knowledge can be used by practitioners in order for them to add them in their work. And to take your initial example, so cases are like each case is an ecosystem. So we try to get different cases, different ecosystems in order to understand the ecology behind trafficking persons or part of the ecology. Of course, we are totally aware that our knowledge is limited, and our work as analysts is really to understand from different aspects, from different elements, how what is this phenomenon of trafficking in persons. So to go to the global report, yes, the global report, the first edition of the global report was published in 2009, and the core source of information for the global report are cases that are detected by national authorities. This, of course, we know that this is only tells us a part of the story, that is what's come to the surface, but it's a fact, it's a solid fact, and we are aware about its limits. So we are not talking about opinions, we're not talking about perception, we are talking about cases that have been detected, and we are aware this is just the tip of the iceberg. So over the course of these more than a decade that I'm working on the global report, basically our approach has been to improve. Every edition is far to be perfect, but is better and informs more than the previous edition, so to speak. So we have been collecting these detected cases of trafficking, mainly administrative statistics, cold statistics, about the profile of the victims, the profile of the offenders, the flows of the citizenship of the victims that have been detected. So over the course of the years, actually, we managed to build up a very large data set. So we have a data set that includes information on about 350,000 victims of trafficking persons detected since the year 2003, which is the entry into force of the protocol, up to 2020, because we are currently collecting data and cases of trafficking. So as said, the first edition, the one that we published in 2009, was very well welcomed from the international community, from the academia, from researchers in general, because it was very informative at that time. But of course, if we read back that edition of the report today, it seems like very flat. So this is why we try to use new sources, and we have been collecting these cases in order to go beyond the information that we get from the cold statistics. And I give you one specific example. In 2009, the first edition of the global report, one of the most striking results, and also quite, let's say, debated. So I remember finding myself in very difficult situations also with colleagues, with researchers, and with practitioners, was about the the role of women as traffickers. So we found at the time, and we reported at the time, that about between 30 and 40% of all people convicted for trafficking persons globally were actually females, or mainly adult women. And that was striking at the time, because normally the gender ratio in all crimes, I am a criminologist by background, so we study these statistics. Normally the gender ratio is 90 or 85% males, 15% women. So having a 30% of all convicted being women, it was a striking result. But of course, this was a result that didn't tell us much on why this. We only knew that value. So, in order to understand what's behind this number, so what is really how trafficking person is functioning, what's the role of women as offenders, we needed to go to the literature, and we needed actually to go to the cases, because the cases, of course, this ecosystem allow us to elaborate more on these indicators. So, of course, it turned out that the role of women was more prevalent in countries of origins, for instance. Rather than in countries of destination, that women were more involved in the recruitment of girls or young women, so on and so forth. But also the fact that sometimes women are used to recruit other women, that sometimes women are actually victims of trafficking, in terms of they are forced to recruit other victims, so and so forth. So that the reality was much more, let's say, elaborate than what a single statistical indicator could tell us. And of course, I also at this point make reference to the studies you have contributed and that was published this year about the role of women defendants. That elaborate even more on this concept. So we found useful to make use of these cases in order to better understand, to go beyond the cold statistics. The statistics that we used to use that represent and that remains, of course, the core indicators in the global report. So how many, what are the nationalities, what is the age profile, the sex profile of victims and offenders, can tell us just as much. Then we need to go beyond that, and cases can be used in order to understand more. So in the latest edition of the report, as you said, we extensively used cases. Of course, we have collected cases over the course of these 15 years. And when we understood we had let's say a core number of cases that we could use in order to come up with something meaningful, we have used it. So that's why we use it in the 2020 edition of the report. We use it extensively on the profile and the role of organized crime, for instance. One of the results that was emerging from this analysis, I found it very interesting, the fact that in terms of cases, we have fewer cases that see the involvement of organized crime group, let's say that organized crime groups that we normally call mafia, let's say, that have a territorial presence, a governance structure, so to speak. So these criminals are involved in less cases compared to the ad hoc traffickers or the individual traffickers, but when they are involved, they traffic more victims for more time, for longer period, and they are more violent than individual traffickers. And these are the sort of information that we can only extrapolate by a systematic analysis, a quantitative analysis of of the cases. Similarly, for instance, the means that are used by the traffickers, not all trafficking is violent as or takes a physical violent form. So we know that, but the analysis of the cases, of course, allowed us also to quantify as much as possible that large number of cases and large number of victims appear to be trafficked by use of more subtle means, like abuse of vulnerability, for instance. And of course, an extensive analysis of the risk factors or the vulnerabilities of victims before being recruited. And it turned out that in most cases and most victims are targeted because they are in economic need. Then very likely there is always a combination of factors, but economic need is always there. And again, this is something that can be can emerge only when looking at the cases and the literature. Of course, we adopt a very rigid and very stringent triangulation and validation also with the literature that is out there. So I go straight also to, at this point, to the limits, challenges, and obstacles. As I said at the beginning, one of the elements that emerged when looking at this analysis was, okay, we have a limited number of cases. How are these cases representative of the entire trafficking phenomenon? And this is true to a certain extent. We have used about 500 cases, and and these cases include information about 3,000 victims. So this for us was the threshold to use these numbers. The 3,000 victims was the threshold we decided we have used in order to start adopting this methodology. Normally, 2,000, from the statistical point of view, a sample of 2,000 units is normally used if randomly. Okay, I will not bore you with this technicality. The technicality is normally used to represent a universe. So this is why we have used these cases now at this stage. There is a fact, though, that these cases can be representative of the population of detected victims, but not of the entire trafficking population, so the entire trafficking phenomenon, especially because most cases, and this is the real limit of this evidence, so to speak, that we use in the analysis, is coming from a limited part of the world. So most of these cases, as most of the data that we receive in general for the global report, is coming from high-income countries, from Europe, from the Americas, from some parts of the rich countries of the Middle East. But this leaves, of course, let's say, a geographical vacuum that is Sub-Saharan Africa, most part of Asia, which of course is a very important part of the world. So I think that when we talk about limits, it's mainly a geographical representation, which is very important, because I was talking before about the role of organized crime, and it's very likely that criminal organizations, structured criminal organizations, are more relevant in Europe than they are in low-income countries. That in that part of the world, probably unstructured forms of trafficking is more present compared to criminal organizations. So it is very likely that there is a geographical bias, that these cases only could be representative of that part of the world that where we collect cases. That I said, we really managed to get only a few cases from West Africa and from South Asia. So we still have to make an effort to mobilize, let's say, information, to mobilize data and also cases from that part of the world in order to have a real global understanding of the phenomenon. And then I'll go back to where I started, that yes, I'm done, is that we really try to use this information in order to enhance knowledge. To initiate sort of this virtuous growth circle. The more we know, the more we are able to combat, to detect, and then the more cases are detected, the more we are able to understand, and so forth. So that was my contribution, and thank you very much.
Fabrizio, thank you very much. Now you have raised our expectations for the forthcoming GLOTIP report that will be also new and improved. And we hope also that we have instituted a tradition with the UNODC Knowledge Week. We had planned one more question for the panelists, but I am afraid we have run out of our time. This means that we have to repeat the same panel maybe next year and continue this very interesting discussion. For those of you that joined later because of a technical issue we had with the links, for which I humbly apologize, please be informed that the recording will be made available on the website of the Knowledge Week so that you can watch it from the beginning. I want to wholeheartedly thank the speakers who join us from different time zones. It was not only a great honor, but also a great joy. If you allow me, since this is the last, since this is the closing session of the Knowledge Week and preparations for the working groups are in full swing, I want to thank everybody that has participated. I want to thank the colleagues that have made this possible, but I also want to thank the volunteers and our interns that did a great job with a lot of enthusiasm. So many thanks to Penguyan, to Liu, to Maria, and to Claudia. We hope to see you next week at the working groups. I hope we gave you a lot of food for thought to consider in the deliberations of the working groups that will convene next week. And we sincerely hope to see you all next year for the second edition of UNODC's Knowledge Week. Thank you once more. Have a good weekend.